In this video, we will discuss when a spouse or partner visa application should be submitted. We will discuss first-time applications, including when the first application is as a fiancé, partner visa extensions, and the indefinite leave to remain application. This is important because getting this wrong can have severely negative consequences and can be very costly. As an OISC regulated UK immigration law firm that has helped more than 4,600 partners obtain their UK partner visas, we're very well placed to discuss this. At this stage, it's important to quickly note two things. Firstly, the application is submitted when you pay the Home Office application fee on the online application form. This applies to all applications, including the indefinite leave to remain application. And as we discuss later on in the video, this date is important for several reasons. Secondly, by spouse or partner visa, we're referring to standard partner visa applications where the sponsor is a British or Irish citizen, has indefinite leave to remain or settled status in the UK, or has one of these. If the sponsor instead has a temporary visa, such as a skilled worker visa, this video will not be relevant. Rather, you should look into applying for a dependent visa. Let's start with when the first time out of country partner visa application should be submitted. By first time out of country partner visa application, we mean applications as a married partner, civil partner, unmarried partner, fiancé, or proposed civil partner when the applicant, the person applying for the visa, is based outside the UK. Like in-country and indefinite leave to remain applications, when the application is submitted is important because the date that the application is submitted is when you must show that the requirements have been met. For example, the sponsor started employment on the 5th of January 2024. The sponsor can only meet the financial requirement under Category A, which requires 6 months employment. If the application is submitted on the 5th of July, 6 months after starting employment, the financial requirements will be met. We discussed the requirements in detail, including the financial requirements, in our Spouse Visa Requirements YouTube video and on our website, www.migrate.org.uk. The date the applicant intends to arrive in the UK is also another consideration when considering when to submit the application. For out-of-country applications, including fiancé visa applications, the online application form will ask for the intended date of arrival in the UK. If the date you list here is before the application is decided, the start date of the visa will be on or around the date of decision. If the date you list here is after the application is decided, the start date of the visa will normally be the date you list here. For those applying as a married, civil or unmarried partner, if the online application form states, after your application has been approved, you will have 30 days to arrange travel to the UK. This is incorrect. You will have 90 days. The online application form is outdated. For those applying for a UK fiancé visa, only the 6-month visa will be issued. Here, you must also consider the 2 to 3 month standard processing time or 30 working day processing time. We discussed the processing time as well as numerous frequently asked questions relating to the processing time in our Spouse Visa Processing Time YouTube video. On the one hand, considering the processing time, you do not want to submit the application too late, but you also do not want to submit the application too early. So when considering the earliest date that you can submit the application, you will need to consider, firstly, the 2 to 3 month standard processing time or 30 working day processing time. Secondly, the Home Office can delay the start date of the visa by up to 3 months after the date the application is decided. And thirdly, for those applying as a married partner, civil partner or unmarried partner, the visa will be a 90-day entry clearance visa, which is separate from the 33-month visa that will also be issued. The applicant will be expected to enter the UK at any point during the 90 days. For those applying as a fiancé, a 90-day entry clearance visa will not be issued. Rather, the 6-month fiancé visa will be issued. So, those making an out-of-country fiancé visa application must also consider the process and practicalities of giving notice, getting married, and then submitting the spouse visa application before the expiry of the 6 months fiancé visa. Regardless of whether the application will be made as a married partner, civil partner, unmarried partner, or fiancé, another consideration is that the applicant should not be in the UK when the application is submitted. So if the applicant is visiting the UK, it's fine to start completing the online application form when the applicant is in the UK. Then you can update and submit the application form once the applicant has returned to the country the application is being submitted from, which will be their country of nationality or a country where they hold any type of long-term visa or residency. And for those making the application outside their country of nationality, in a country where they hold any type of long-term visa or residency, the validity of that visa will normally need to be considered, since the applicant will need to collect their passport in that country once the application is processed. First-time in-country partner visa applications. Let's now discuss when to submit the first-time in-country partner visa application before discussing partner visa extension applications. By first-time in-country partner visa applications, we mean applications where the applicant is already in the UK on a non-visitor visa that has been issued for longer than 6 months, such as a graduate visa, skilled worker visa, youth mobility scheme visa, or a long-term student visa. Here, we will also discuss those already in the UK on a valid fiancé or proposed civil partnership visa, since the approach is similar. Firstly, generally speaking, the application should ideally only be submitted once the requirements are met. This is particularly the case if you plan on getting a partner visa within the much preferable 5-year route to indefinite leave to remain, rather than the 10-year route. We discussed the requirements in detail, including the financial requirements, in our spouse visa requirements YouTube video. Secondly, the immigration rules state that both the applicant and the sponsor must be in the UK. Thirdly, you should be aware that if the applicant leaves the UK whilst the application is being processed, this will withdraw the application. The standard processing time here is 6 to 8 weeks, and this can be reduced to 1 working day if you opt for the super priority service, which is currently only purchasable on the online application form payment page. When is the earliest the first-time partner visa application can be submitted? For those in the UK on a fiancé or proposed civil partnership visa, since the requirement is that you're married or civil partners, the marriage or civil partnership must have taken place before submitting the application. For those applying for the first time as a married, civil, or unmarried partner, the application can be made at any time when the applicant has valid leave. There is no 28-day rule, which we will discuss in relation to partner visa extensions. Partners often prefer to switch to the partner visa route sooner rather than later. For example, the sooner those on a skilled worker visa can obtain a partner visa, the sooner they will stop becoming dependent on their employer. Another consideration here is that the 5 years indefinite leave to remain qualifying period resets when you switch into the partner visa category. So switching into the partner visa route will result in the applicant reaching the required 5 years indefinite leave to remain qualifying period earlier. This is also relevant to those in the UK on a fiancé or proposed civil partnership visa, as the 5-year qualifying period starts only once the spouse or civil partnership application has been granted. Also, considering the partner visa fees tend to go up most years, switching to the partner visa route earlier may save you money. The latest the application can be submitted is the last valid day of the visa or leave, although we would not necessarily recommend leaving it that late due to the possibility of the application form having technical issues or just general life events happening. Submitting an application 1 or 2 days before the applicant's leave or visa expires is generally fine, because submitting a partner visa application automatically extends the then valid leave or visa until a decision has been made or until the application is withdrawn. This is due to what is known as Section 3C leave. In addition to the expiry date being extended, so too will the conditions of the then current leave. So, even though the standard processing time is 6 to 8 weeks, applying a few days before the expiry date of the current leave will not mean that you'll have to pay extra for the super priority service because the leave is expiring soon. Partner visa extensions. Let's now discuss when to submit the partner visa extension. By partner visa extension, we're referring to the application that must be made when the applicant is extending their first 33-month or 30-month partner visa. For applicants who were granted a 30-month visa because they made their first partner visa application as a married, civil, or unmarried partner from inside the UK, the partner visa extension application should be submitted within the 28 days before the expiry date of the partner visa. For applicants who first applied for a fiancé or proposed civil partnership visa and were then granted a 30-month visa as a married or civil partner, the extension to that visa should also be made within the 28 days before the expiry date of the partner visa. For applicants who were granted a 33-month visa because of making their first partner visa application as a married, civil, or unmarried partner from outside the UK, the application must be submitted either no more than 28 days before their leave or visa is due to expire, or no more than 28 days before they've completed 30 months in the UK with a partner visa. With this being said, we generally recommend applying no more than 28 days before their leave or visa is due to expire. This is because 1. This will give greater flexibility regarding when the ILR application can be made, and 2. This will prevent you from making the mistake of applying too early. Keeping things simple where possible is something that we generally recommend. If the application is made too early, an additional partner visa will likely need to be applied for, costing you thousands in additional fees and many additional hours going through the application process. The latest a partner visa extension could be submitted will be the last date of valid leave, although we wouldn't normally recommend leaving it that long. As long as the application is submitted when the partner visa is valid, the partner visa will automatically be extended until a decision has been made or until the application is withdrawn. So there should be no fear of overstaying due to the processing time of the partner visa extension. Due to what is known as Section 3C leave, the same conditions of the partner visa will be automatically extended, so the applicant can continue working in the UK, for instance. What if you're unsure of the partner visa's expiry date? This will be as stated in the decision letter that is normally emailed to partners following the grant of a partner visa, so you can check your email around the decision date of the previous partner visa application. Another consideration regarding when to submit the application is that the applicant cannot leave the UK whilst the application is being processed, as doing so will withdraw the application. So, if you anticipate the applicant wanting to leave the UK within the standard processing time of 6 to 8 weeks, you may decide to opt for the super priority service, which reduces the processing time to 1 working day. Please also note that the immigration rules state that both the applicant and sponsor must be in the UK when applying for a partner visa extension. Again, the application should ideally only be submitted once the requirements are met. But what if the requirements are not met on the date the application is submitted? On this point, the Home Office guidance states, where people cannot satisfy the requirements of the 5-year route immigration rules to remain in the UK, they are expected to leave, and it is natural to expect that it is reasonable for any child or children to leave with them. Only where there is something in the evidence to suggest that it will be unreasonable for a child to leave, where there are insurmountable obstacles to family life with a partner outside the UK, or exceptional circumstances, that the family who would otherwise be expected to go will satisfy the requirements under the rules or the exceptional circumstances policies to enter or remain on a 10-year route. The financial costs alone of not meeting the requirements of the 5-year route and instead being granted on the 10-year route are severe, particularly since switching from the 5-year route to the 10-year route resets the qualifying period. The ILR application. Let's now discuss when to submit the Indefinite Leave to Remain application, otherwise known as the ILR application. For those in the 5-year route to Indefinite Leave to Remain, which is most partners, the Indefinite Leave to Remain application can be made after 5 years with leave as a partner on the 5-year route to Indefinite Leave to Remain. This means that the route to ILR for applicants who first applied out of country as a married partner, civil partner or unmarried partner typically involves the first out of country partner visa application, which will be granted for 33 months, the first partner visa extension application, which will be valid for a further 30 months, and then assuming the first spouse visa application and the first spouse visa extension were granted under the 5-year route to ILR, the Indefinite Leave to Remain application. For applicants who first applied out of country as a fiancé or proposed civil partner, the route to Indefinite Leave to Remain typically involves the fiancé or proposed civil partnership visa application, the first application as a married or civil partner, the first spouse visa extension application, and then the Indefinite Leave to Remain application. And for applicants who first applied for an in-country application as a married partner, civil partner, or unmarried partner, this typically involves the first partner visa application, the first partner visa extension, and then the Indefinite Leave to Remain application. For all of these typical routes, we've assumed that applications were granted under the 5-year route to ILR, which is most commonly the case. Let's discuss the 5-year qualifying period and how to calculate it. So, as previously mentioned, applicants can normally apply for Indefinite Leave to Remain after 5 years, which is 60 months, with leave as a partner on the 5-year route to Indefinite Leave to Remain. Earlier in this video, we discussed when to apply for the partner visa extension. To recap, if the first partner visa as a married, civil or unmarried partner was made from inside the UK, the extension application should be submitted within the 28 days before the partner visa expires. If the first partner visa as a married, civil, or unmarried partner was made from outside the UK, the extension application should be submitted either within 28 days before the expiry of the partner visa, or no more than 28 days before they've completed 30 months in the UK with the partner visa. If this was done, and if the ILR application was submitted within the 28-day period before the leave as a partner expires, the starting point is that the 5-year qualifying period will be met. As stated in the guidance, where a person submits an Appendix FM partner application up to 28 days before they've completed 30 months in the UK with leave to enter or remain as a partner under Appendix FM, that person will be considered to have met the required continuous residence period of 30 months as a partner. The 5 years qualifying period does not necessarily require 5 years of being physically present in the UK. Rather, the qualifying period is primarily concerned with the applicant being granted a partner visa under the 5-year route for 5 years. One common misconception for the partner visa extension and indefinite leave to remain application is that partners cannot be absent from the UK for more than 180 days in any 12-month period without permitted reasons. As we discussed in our UK spouse visa requirements video, the initial partner visa and partner visa extensions require an intention to permanently live together in the UK. The same approach to this requirement should be adopted for the indefinite leave to remain application. When it comes to this requirement, substantial periods of time spent outside the UK should not be problematic if the reasons for the time spent outside the UK are consistent with the intention to permanently live together in the UK. So, for example, a partner spending 9 months outside the UK due to work commitments, or one or both partners spending time outside the UK due to a family illness, are typically good reasons for spending time outside the UK. Due to the Home Office guidance not stating a maximum number of days an applicant can be absent from the UK, where there have been absences, there will be a degree of subjectivity. Therefore, if a significant amount of time has been spent outside the UK, particularly for reasons which may suggest that there is no intention to live together in the UK, the application should be handled particularly carefully. We discussed this further in our How Many Days Can Those in the UK on a Spouse or Partner Visa Spend Outside the UK YouTube video. For applicants who eventually intend to apply for British naturalisation, please note that there are a specified number of days the applicant can be absent from the UK for that application. This is a topic which comes with many exceptions and caveats, but in summary, applicants married to a British citizen must not be absent from the UK for more than 270 days in the 3 years before applying, and must not have been absent from the UK for more than 90 days in the 12 months before applying. Applicants who are not married to a British citizen must not have been absent from the UK for more than 450 days in the 5 years before applying, and must not have been absent from the UK for more than 90 days in the 12 months before applying. Again, there are many exceptions and caveats to this. We won't elaborate further in this video since this is a huge topic in itself, but if you want more information about this, specifically as it relates to the British citizenship application, which must be applied for after the indefinite leave to remain application, this can be found in the Nationality Policy, Naturalisation as a British Citizen by Discretion Home Office document. There are a few caveats regarding calculating the 5 or 10 year qualifying period for indefinite leave to remain. Firstly, if the applicant first applied for a fiancé visa, time spent in the UK as a fiancé does not count towards the 5 or 10 year qualifying period for ILR. Secondly, the qualifying period resets where there has been a change in sponsor partner. Thirdly, if the applicant is in the UK on a partner visa granted on the 5-year route and is subsequently granted on the 10-year route, or vice versa, the qualifying period will reset. Fourthly, if the applicant switches to a partner visa from a different category, the 5 years period will reset. For example, an applicant was in the UK on a skilled worker visa. After 2 years in the UK on a skilled worker visa, the applicant obtained a partner visa on the 5-year route. The start of the 5-year period will reset when the UK partner visa is granted, as the time spent in the UK on a skilled worker visa will not count towards the 5-year period. It may also worth be noting here that if a partner changes from an unmarried partner to a married partner or civil partner throughout the 5-year period, this will not reset the 5-year period. The earliest the ILR application can be submitted is 28 days before the applicant meets the 5-year qualifying period. If an application is made before this, the application may be refused. The latest the ILR application can be submitted is the last day of valid leave of the UK partner visa. Please do not let the partner visa expire. As long as the ILR application is submitted before the partner visa leave expires, the partner visa will be automatically extended until a decision has been made or until the application is withdrawn. So it's normally perfectly fine to submit the indefinite leave to remain application 2 days before the partner visa expires. In such a case, the applicant can continue to live their life normally during the processing of the application and can continue their employment or self-employment in the UK. Like other in-country applications, the applicant cannot leave whilst the application is being processed, as to do so will withdraw the application. So if you anticipate that there's a possibility of the applicant having to leave the UK within 6 months of submitting the application, you may consider paying for the super priority service, which will reduce the processing time to 1 working day on average. For a detailed account of all of the UK partner visa requirements, we have a YouTube video discussing that. We also have a detailed video on the UK partner visa process, both of which you can see here.